right. Welcome everyone to KSSP Podcast Live. I'm Katie.
I'm Spencer.
We're going to be listening to the oral argument audio of the Gonzalez versus Google LLC case. And we might have to do this in 2 parts, depending on how long it goes, but we're going to at least start it off today.
I don't think it...
It's 2 hours and 40 minutes.
Oh, sorry, were you... It didn't connect to Facebook for some reason.
Oh, that's weird. It said it was going to.
That's fine, I guess. I don't, because you put in like the stream key and URL in it.
Yeah.
Okay, then I don't know why it hasn't been connected.
That's okay though.
Yeah, that's fine.
We'll just stay on Twitch and YouTube today.
Yeah.
Alright. I might just keep it on this page so we can pause it when we need to.
Oh,
the oral argument page. With audio. Okay, are we ready?
Yeah, you can start it.
Let's do it.
We'll hear argument this morning in
And you can hear it?
Yes.
case 2130.
You heard that?
Like, the audience can hear me.
Yeah. I think they can. Is your audio not working?
Yeah, I think I can. Well, I just wanted to...
Oh, you're just checking?
Sure. Yeah.
For sure.
Oh, I just wanted... Oh, yeah, you can...
Okay.
Yeah, we can... Let's do this.
Alright, let's get started on this.
Yeah.
We'll hear argument this morning in case 21-1333, Gonzalez versus Google. Mr. Schnapper?
Mr. Chief Justice, and may it please the Court, Section 230C1 distinguishes between claims that seek to hold an internet company liable for content created by someone else and claims based on the company's own conduct. That distinction is drawn in each of the 3 sections of the statute. First, Section 230C1 is limited to claims that would treat the defendant as the publisher of third-party content. The statute uses publish in the common law sense. The Fourth Circuit decision in Henderson correctly interprets this statute in that manner and concludes that it involves 2 elements. The claim must be based on the action of the defendant in disseminating third-party content, and the harm must arise from the content itself. Second, Section 230C1 is limited to publication of information provided by another content provider, which is often referred to as third-party content. The statutory defense doesn't apply insofar as a claim is based on words written by the defendant or other content created by the defendant. In some circumstances, the manner in which third-party content is organized or presented could convey other information from the defendant itself, as the government notes. Third, Section 230C1 only applies insofar as a defendant was acting as an internet computer service. Most entities that are internet computer services do other things as well. This court technically is an interactive computer service because of its website. It does other things as it is doing today. Conduct that falls outside that line of activity is outside the scope of the statute. A number of the briefs in this case urge the court to adopt a general rule that things that might be referred to as a recommendation are inherently protected by the statute, a decision which would require the courts to then fashion some judicial definition of recommendation. We think the court should decline that invitation and should instead focus on interpreting the specific language of the statute. I welcome the court's questions.
Mr. Schnapper, just so we're clear about what your claim is, are you saying that YouTube's application of its algorithms is particular to, in this case, that they're using a different algorithm that to the one that say they're using for cooking videos, or are they using the same algorithm across the board?
It's the same algorithm across the board.
So what is if it's the same algorithm? I think you have to give us a clearer example of it. What your point is exactly? The same algorithm to present cooking videos to people who are interested in cooking, and ISIS videos to people who are interested in ISIS, racing videos to people who are interested in racing. Then I think you're going to have to explain more clearly, if it's neutral in that way, how your claim is set apart from that.
Surely.
So, okay. With the algorithms, the thing with them is like, the people who make them don't even really understand how they form the algorithms that they form. So right now it's just something that's really unregulated in the marketplace. Like, people can just make algorithms, and if something bad happens, usually they just say, oh, well, that was just unpredictable. We couldn't have predicted that. So I think they need to look into how their algorithms actually work more, so that we don't have these problems.
If I might turn to the practice of displaying thumbnails, which is a major part of what's at issue here. The problem and the issue is not the manner in which YouTube displays videos. It actually displays, as you doubtless know from having looked at these little pictures, which are referred to as thumbnails. They're intended to encourage the viewer to click on them and then go see a video. It's the use of algorithms to generate these thumbnails that's at issue. And the thumbnails, in turn, involve content created by the defendant.
But it's basing the thumbnails, from what I understand, is based upon what the algorithm suggests the user is interested in. So if you're interested in cooking, you don't want thumbnails on light jazz. It's neutral in that sense. You're interested in cooking, say you get interested in rice and pilaf from Uzbekistan. You don't want pilaf from some other place, say Louisiana. I don't see how that is any different from what is happening in this case. And what I'm trying to get you to focus on is are we talking about the neutral application of an algorithm that works generically for pilaf and it also works a similar way for ISIS videos? Or is there something different?
No, I think that's correct. But our view is that the fact that an algorithm is neutral doesn't alter the application of the statute. The statute requires that one work through each of the elements of the defense and see if it applies. The lower courts in a couple of cases have said that, really disregarding the requirements of the defense, that as long as an algorithm is neutral, that puts the conduct outside within the protection of the statute. But that's not what the statute says. The statute says you must be the claim must treat you as a publisher.
Well, but I mean, the difference is that the Google, YouTube, they're still not responsible for the content of the videos or text that is transmitted. Your focus is on the actual selection and recommendations. They're responsible that a particular item is there, but not for what the item says. And I think part of it may be significant if the algorithm is the same across, as Justice Thomas was suggesting, across the different subject matters, because then they don't have a focused algorithm with respect to terrorist activities or pilaf or something. And then I think it might be harder for you to say that there's selection involved for which they can be held responsible.
The statute, I think, doesn't draw the distinction that way. The claim here is about the encouragement of users to go look at particular content. And that's the JASTA claim that we'll hear about tomorrow. And the underlying substantive claim is encouraging people to go look at ISIS videos would be aiding and abetting ISIS. More on that tomorrow. But if that's an actionable claim, then the conduct here would fit within it. Because certain individuals would be shown these thumbnails, which would encourage them to go look at those videos.
So I think you're right, Mr. Schnapper, that the statute doesn't make that distinction. This was a pre-algorithm statute, and, everybody is trying their best to figure out how this statute applies. The statute, which was a pre-algorithm statute, applies in a post-algorithm world. But I think what was lying underneath Justice Thomas's question was a suggestion that algorithms are endemic to the internet, that every time anybody looks at anything on the internet, there is an algorithm involved, whether it's a Google search engine or whether it's this YouTube site or a Twitter account or countless other things, that everything involves ways of organizing and prioritizing material. And that would essentially mean that, 230, I guess what I'm asking is, does your position send us down the road such that 230 really can't mean anything at all?
I don't think so, Your Honor. The question, as you say, algorithms are ubiquitous, but the question is, what does the defendant do with the algorithm? If it uses the algorithm to to encourage people to look at ISIS videos, that's within the scope of JASTA. It's not different than if back in 1996, a lot of clerks somewhere at Prodigy did this manually, and just they had a bunch of file cards and they figured out who was interested in what. The statute would have meant the same thing there that it does now. It's automated, it's at a larger scale, but doesn't change the nature of what they're doing with the algorithm.
I'm sorry, finish.
The brief, I think the briefer respondent points to a number of uses of algorithms, for example, to pick the cheapest fare or things like that. That's just outside the scope of the statute. The algorithms being used there to generate additional content. So the question is what you do with the algorithm. The fact that you did it with an algorithm doesn't yield a different result than if you had a lot of hardworking people in an office somewhere doing the same thing.
I guess I take the point, if I could.
No, go ahead.
I take the point that there are a lot of algorithms that are not going to produce pro-ISIS content and that won't create a problem under this statute. But maybe they'll produce defamatory content, or maybe they'll produce content that violates some other law. And your argument can't be limited to this one statute. It has to extend to any number of harms that can be done by speech and so by the organization of speech in ways that basically every provider uses.
Well, if I might turn to the example of what we referred to, an algorithm that produces defamation. I'm maybe paraphrasing that wrong. If the say the algorithm generates a thumbnail that on its face is benign, it just says interesting information about Frank. You go there and it's defamatory. The defendant's not responsible, the defense applies to the video itself that you saw. The question would be whether the thumbnail was actionable. And in most circumstances, thumbnails aren't going to be actionable.
So is this more, it sounds like it's more about the thumbnails than the actual recommendation, like the whole recommendation algorithm. I don't know why they're
Yeah.
specifically focusing on the thumbnails.
Well, I know when I was reading my YouTube book, thumbnails play one of the biggest roles in the algorithm. Like that's your thing that the algorithm looks at, and that's like the most important thing. So I get like,
Okay.
but I guess so. So his argument is that YouTube is responsible because the algorithm goes after the thumbnails.
Right. Okay.
In addition, the thumbnails typically include a snippet from a video or text or whatever. If the snippet itself were defamatory, again, the statutory defense would apply because what was being displayed was third-party content. And so the statute still applies there.
I suppose that YouTube could display these thumbnails purely at random. But if it does anything than displaying them purely at random, isn't it organizing and presenting information to people who access YouTube?
Yes, but
All right.
that doesn't put it within the scope of the statute.
Well, does that constitute publishing?
Yes, so they would be publishing. They would be publishing the thumbnail.
Right.
But if the thumbnail isn't itself, if the way they're using it is encouraging people to engage.
Well, that's a different question, though, isn't it? I don't know where you're drawing the line. That's the problem.
Yeah,
That's the problem that I see.
Oh yeah.
I feel as confused as the judges, I feel like. Because what is he... So, he's arguing against Google and Facebook, right? Or no, not Facebook, YouTube.
Yeah, I think there's one... I thought there was one person arguing for and one against.
Well, I think this has all been Mr. Schnapp. I don't know how to say things, but...
Is he the defense or the prosecution?
I
don't know if it works that way in Supreme Court, but...
I think it does. I just don't know who is... Is Google the defense? Like they're
Yeah, Google is the defendant.
Okay, then I think this is the other one.
Oh, so this is the Gonzalez, so this is the prosecution. Okay.
Yeah, I think so. But I guess it's just confusing as to...
It would be nice to have visual, like video, so we could see who is talking.
Yeah. But I'm just... Hold on, I lost my thought and I lost my page. So basically, I thought I was going to... Because, yeah, I get thumbnails. Like, I feel like I get what you think, and I get what they're saying.
Yeah. Like, I mostly get what they're saying. I mean, they're basically just arguing that because they push this video through the algorithm, then that makes YouTube or Google the publisher of the video. Because they publish it through the algorithm. Even though a third party uploaded the video. Like, the algorithm is considered a
trying to think more so about that with the algorithm, they are encouraging people to watch videos related.
Right, yeah.
Which, like, I get. And I didn't think if they created the algorithm, then they created it that way. They can't feign ignorance if they created it.
Right.
Like, obviously, the publisher of the videos are responsible for their content.
Right.
But I guess Google, YouTube could get in trouble for the like just the algorithm, like how it works.
Yeah.
If it is pushing dangerous content to people.
Yeah, but then if they get rid of Section 230, then, like, we're not going to have social media anymore, pretty much. Or, like, it's completely going to change. Like,
Oh, yeah.
Like, it's only going to be people who make the company money that are able to publish. And then there's not going to be, like, new content creators and...
Yeah, I guess I don't know much about Section 230, but obviously if that isn't something that we would want, basically I don't think they should be responsible for the content, but their algorithm.
Right.
But
like
maybe that needs new legislation.
Right, they need a whole new piece of legislation for algorithms specifically. Yeah. Instead of just getting rid of Section 230, because that would be a mess. But
I think it's good to start having this conversation, especially with like the Supreme Court, I guess. But I don't see the best decision to get rid of 230. If that's what their decision is, would be.
Yeah.
I don't know.
You're saying that the publication requirement is satisfied under all circumstances unless the thumbnails are presented purely at random.
It's publication even if it's at random, but the injury in the hypothetical we're talking about ISIS doesn't follow from the content of the thumbnail. The thumbnail would typically be fairly benign. The harm comes...
Yeah, but in every instance, in those instances where the thumbnail is benign, that's not a concern for purposes of this case. But in all those instances where some plaintiff might have some cause of action based on the content of the video that has been posted.
But then, okay, and the algorithm, if ISIS wanted to post more video, couldn't they just put a completely random thumbnail so that they wouldn't get flagged? By the algorithm and put completely random stuff and then information and then just publish their videos. That would be hard to regulate.
What do you mean?
Well, because they're talking about how the algorithm uses the thumbnails to recommend videos, right?
Yes.
So they were talking about cooking, having cooking thumbnails, but what if ISIS wanted to continue posting videos and they put a picture of a rotisserie chicken or something on their thumbnail? And then the algorithm flags that as a cooking video, how would then in that case would you still be holding Google responsible?
Well, algorithm also does listen to the video. So it would know the content.
Oh, okay. The algorithm does scan the whole video?
Yes.
Oh, okay.
At least that's what the book that I read said.
Okay, I did not know that.
Listen to everything that you say in the video, so it knows all the content. And then it'll listen to how you present that, if it's professional or I guess I don't know, you're just you're not professional.
Yeah.
So it listens to your style, I guess too.
Okay.
So, and I guess but if they their whole account should just be flagged, and taken down. ISIS should be able to have accounts.
Yeah, there's so many videos that get posted on YouTube every day, though. They don't have enough staff or algorithms to scan through all of that, accurately, 100%,
Yeah, so maybe they need to.
Yeah, they should.
As a company,
right? They should be held. They should be held more responsible for not regulating the content, rather than being held responsible as the pusher of the algorithm. In my opinion. But I don't even think I don't know if there are laws. There are laws. No, I do know there are laws that they have to regulate their content to a certain degree. but those laws should either be stricter or better enforced.
Yeah.
Because, like, they have the money. It's not like they don't have the money to hire more people, you know?
Yeah, exactly. That's the biggest thing. Like, what is... I mean, I'm gonna Google. Google CEO Sundar... I don't know how to say that last name. He gets $242 million pay package.
You said 242 billion? Million. That's it? I mean, that's a lot of money, don't get me wrong. But I thought it would be more than that.
I mean
that's
like
just the CEO, though. That's not like the revenue of the company.
Top of a $2 million annual salary.
And that's just
So
a
it's
salary,
$2
too.
million.
Like, they get paid in other ways through the company, too, besides salary.
Well, the $2 million is salary, and
Right.
then $240 million is a stock package.
Stock package, yeah. That makes sense.
Yeah, but I mean, even like, what if you made $1.95 million a year so that they could use that other money to hire more staff?
Right. I mean, it
Help
wouldn't cost
regulate.
that much more of the money. Like, you'll be okay
No.
without an extra $5 million when you've got...
$1 million
So
in
much.
annual salary. That's crazy.
Yeah.
Nobody needs that.
Yeah. It's,
I'm not saying that people
And, like,
don't want that.
I don't
but-
even think are the stock options taxable? I don't think they are.
That I don't know. I think it depends on if he sells it.
Yeah,
Like,
but
if
if
he
he
doesn't
doesn't
sell
sell
his
it, then
stock,
it's not
then-
taxable, I don't
No.
think.
But once he sells it, then you have to pay
Yeah, yep, that's
sales
right.
tax, or I don't know what kind of tax it is. But
Some kind of tax, though.
yes, there is a tax.
It's crazy.
There would have to be a cause of action, as we assert there is in JASTA, for encouraging people to go look at the video. That's a fairly uncommon form of cause of action. The cause of action, insofar as the plaintiff asserts a cause of action based on the video itself, that you've been sent to, that's within the scope of the defense.
Is that because of the way in which you're interpreting the statute? I mean, can we back up a little bit and try to at least help me get my mind around your argument about how we should read the text of the statute? I took your brief to be arguing, and that of those who support you, that the statute really is about one kind of publishing conduct, and that is the failure to block or screen offensive content. Am I right about that? In other words, what you say is covered by Section 230, and that Google could rightly claim immunity for is a claim that there was something defective about their ability to screen or block content, that the content is up there and you should be liable for it.
I think I think that's not our claim.
Okay.
I think we are trying to distinguish between liability for what's in the content that's on their websites that you could access, and actions they take to encourage you to go look at it.
Yes, that's your claim. I'm just
It's
trying to understand how you
encouraging.
read the statute. The statute, you say, covers only scenarios in which the claim that's being made is that there is offensive content on the website, that you didn't take it down, that you failed to screen it out. But if you're making a claim that you're encouraging people to look at this content, that's something different. That's the claim you're making, and it's not covered by the statute.
That's the distinction we're trying to draw. I mean, the distinction is illustrated by the email in the Dyroff case, which is the precedent that got us here in the Ninth Circuit. In that case, there was I think 26 word email from the website to an individual, which read something like, "There's something new that's been posted to the question, where can I buy heroin in Jacksonville, Florida? To access it, use this URL or use this URL." Our contention that is outside the protection of the statute.
Is that really different? I guess I'm trying. So they would argue, I think, that even assuming that the statute only covered the kinds of things that you say it covers, defective blocking and screening, meaning there's still offensive stuff on your website and you should be liable for it. I think they would say that to the extent your claim is talking about their algorithm that presents the information, it's really the same thing. It's tantamount to saying we haven't, blocked this information. It's still on the website because algorithms are the way in which the information is presented.
So again, to try and make clear, as I may not have done that well, the distinction we're drawing. Our claim is not that they did an inadequate job of keeping things off their computers that you can access from outside, or from failure to block it. It's that's the heartland of the statute. What we're saying is that insofar as they were encouraging people to go look at things, that's what's outside the protection of the statute. Not that the stuff was there. If they stopped recommending things tomorrow and all sorts of horrible stuff was on their website, as far as we read the statute, they're fine. It's the recommendation practice that we think is action.
Can I break down your complaint a moment? The vast majority of it is paragraphs after paragraphs after paragraph that says they're liable because they failed to take ISIS off their website. I think, as I'm listening to you today, you seem to have abandoned that and are saying they don't have to take it off their website. Am I correct about that?
That's exactly right. That is the way we framed the question presented. We did not advance that claim.
So you're abandoning that claim. So that can't be aiding and abetting. So I think I'm listening to you. And the only aiding and abetting that you're arguing is the recommendation, correct?
That's correct.
You're not arguing that some of these providers create chat rooms or put people together, users together. You're not claiming that that's part of what you're arguing about? The social networking, I want to call it.
Well, that's not an issue in this case.
It's in tomorrow's case.
If I can be more specific, Facebook does that. Facebook recommends people,
right,
which is very difficult to find within the four walls of the statute. Google's created a lot of things, but so far.
But you're not claiming that in this case.
I mean, it's like the same thing, except instead of a text post, it's just a video.
What do you? Oh, like they're...
Yeah, like between Facebook and YouTube or whatever. Like what they're talking about now. And they're trying to make a distinction between it. They're trying to say, oh, well, Facebook is people posting on there. But it's like, yeah, so is YouTube, though.
Well...
I guess I don't understand what kind of...
Well, he said Facebook recommends people.
Yeah.
So not people's content, but people profile.
Oh, okay. Is he talking about the profiles then? Okay.
I think so. Because I guess when I'm on Facebook, I don't see random posts unless I'm in their group. They don't pop up, on YouTube, a random video can just on your homepage.
I get random posts on Facebook from people I don't follow.
Oh.
On my feed, yeah. Not even ads, just other groups and stuff like that. I get a bunch of Jesus ones for some reason. Yeah.
They just show up?
Yeah. Oh, yeah. They have random... It's not just people you follow on your news feed. At least for me.
I have not been on Facebook. I'm just going to look at my Facebook quick.
Yeah.
On this... Hold on, let me... on this main page, when you first sign it, can you see that a little?
No, I cannot see your screen. On your phone? I can kind of see it, yeah.
But, I get, sponsored. But you'll just be scrolling on... Well, I guess... Oh no, there. Okay, here's a suggestion for you, Paul. Okay,
Yeah.
interesting.
So it's like the same thing. I mean, it's just a different form of media, but it's like the same thing.
But no, I'd say. Yeah, I'd still say it's the same though.
Yeah.
If even more invasive, kind of.
Yeah.
But maybe not really. But I don't know. I mean, I guess when you're scrolling on your homepage on YouTube, like people you're subscribed to.
Yeah, like, at least on my phone, like, it's mostly people I'm subscribed. Sometimes it's not people I'm subscribed to, though. But it's, like, related people.
Okay.
Like,
yeah,
similar
I guess
to...
for you, kind of the same. If people don't... I guess I just feel it's more invasive because it's... I don't know, Facebook always was supposed to feel more intimate, I guess you could say.
Yeah.
Because it's more like your friends and family.
Right.
So then they're throwing, like, I guess in this case, ISIS stuff on your, like, homepage. It's kind of, like, weird. It's weird.
Yeah.
It shouldn't be anywhere, but I didn't know Facebook started doing that. Because they didn't always do that, right? You knew it used to just be your friends and pages you followed.
I think so. Way back in the day, yeah.
Okay.
I think so. Because, like, this is before, like, Facebook groups and everything, though. I think Facebook groups changed it up.
Okay.
For a lot of people.
So then, yeah, I guess... I mean, their algorithms are probably different, though, because...
Oh, yeah.
Obviously, Facebook doesn't... Or maybe, like, for videos, it looks at the thumbnail still.
Yeah.
But...
I think every, like, social media site has its own unique algorithm.
Okay. So still, in that case, they should be responsible for the algorithm, not the content. Well, I mean, like...
They need to be able to understand their algorithms better than they do.
Yeah, because, I mean, they created it. It's not like it just spawned out of nowhere.
Right.
Like, machine learning, you have to... Because that's what an algorithm is, right? Is it a machine learning?
Yeah, pretty much. Yeah, it's
like
a form of AI.
Like where you throw in things and then it learns.
Right, like AI, yeah.
Okay. I still don't understand it fully, but they should because it's their thing.
Oh, the Supreme Court's not going to fully understand this at all.
No. Like Facebook and YouTube.
Oh, like the company should. Oh, yeah,
they don't
for sure.
Really have an excuse to not understand it.
Right.
That'd be like creating something and throw, like, I don't know, like a AI robot and putting it out into the world and be like, well, I don't know what it's going to do.
Yeah.
Well, you should, because it's your invention. You're responsible for it.
Exactly. Like, if you make an AI robot and it goes out and it, like, stabs somebody, like, you can't just be like, oh, well, the AI was unpredictable.
Yeah. You know? That's just feigning ignorance, and I don't
even think it's feigned ignorance. Like, it's really just it's a genuine ignorance in the industry because they just don't care to learn. They're just trying to learn what they can that'll make them money.
Yeah.
Like, they're not trying to look out for the best interest of everybody at heart. You know what I'm saying?
Then they shouldn't own businesses.
Yeah, definitely not social media businesses, but
no.
Here we are.
But yeah, I don't.
I'm just gonna make this bigger. Oh.
What'd you do?
Oh. I'm trying to move the chat box. It's fine. I'm just being a perfectionist with the Streamlabs settings. But yeah, okay. Should we continue?
Yeah.
Okay.
You're just focusing...
No, this is about content. It's not about...
This is about content. And I just want to focus your complaint so I understand it very clearly. You're saying the YouTube or the next up feature of the algorithm that says you viewed this, and so you might like this. It's you might like this that's the aiding and abetting? What part of what they're doing? Because, I mean, you whoever the user is types in something. They get an ISIS video. You say that's okay. They can't be liable for you, the viewer, looking at the ISIS vehicle.
Oh wait, so this is the defense.
What do you mean?
Because she just said he's arguing that they should not be liable.
Well, he's saying that they shouldn't be liable for their. They shouldn't be liable if they don't remove videos. They should be liable for their algorithm.
Right. Yeah.
So
I might have just misheard her too.
Well, they're just trying to understand. Like, I don't.
Right. They're just trying to understand it. I mean, I get that, but yeah.
Well, and I feel like they should understand.
They should really have like at least one younger member in the Supreme Court who understands technology, because I feel like that's going to be a huge barrier in this case. Like, the people in the Supreme Court just don't understand the technology.
But I also think they're just going like back and forth on the same.
Yeah, they're just saying the same thing over and over again.
Yeah.
Because I think it's just because they don't understand it, though.
And yeah, that could be it.
But like, they should have somebody like who understands it and can explain it a little bit better, so that they can understand it. Or like, I don't know. There needs like something. You know, this way this is working is not. It's not going well so far.
Well, yeah, it's just like I feel like there's just miscommunication between them two.
Yeah.
Misunderstanding.
Yeah, exactly.
Like his point is that like he isn't arguing that they are responsible because they don't remove ISIS videos. He's arguing that they are responsible because their algorithm will push ISIS videos.
Yeah. And like algorithm, like pushing the videos is as they say, like the aiding and abetting to the crime.
Yeah, but I don't know why they don't understand. But it depends. But I think they're trying to understand how the 230 relates to them.
Right. How it applies and everything.
Applies to content.
Right. Yeah.
But there was a pre-algorithm.
Right, because they wrote that in like what I think 1996 or something like that.
Oh, I didn't.
Like it's pretty. I think it was 1996 when they wrote it.
Okay, I don't even think the algorithms were on their mind.
Right, they didn't even have algorithms, so.
No.
And I think they were saying that earlier too. Like they were talking about that a little.
But the internet providers can be liable for what?
Okay, so
they're showing me the next video that's similar to that?
All right. It would be helpful perhaps if I distinguish between two kinds of practices that go on at YouTube. The complaint doesn't describe them in detail, but we're fairly familiar with them. So
I'm glad, but I'm going to be looking at your complaint because it can only survive if the complaint is adequate. So you're going to have to tell me where in the complaint you're saying this if I'm going to think about holding them liable. So you're going to have to separate out the two things.
I'm about 3 questions behind. Let me try to do my best here. So what we've been talking about up until now is the use of thumbnails to encourage people to look at content. People haven't clicked on any video yet, and our contention is the use of thumbnails is the same thing under the statute as sending someone an email and saying you might like to look at this new video. Now, the up next feature is a different problem. And the problem there is that when you click on one video and you pick that one, YouTube will automatically keep sending you more videos which you haven't asked for. That, in our view, runs afoul of a different element of the statutory defense.
I mean, you can turn it off, though. I mean, they're not forcing you to autoplay videos.
Oh, yeah.
Like, there's a little button for that.
Which is that they be acting as an interactive computer service. And when they go beyond delivering to you what you've asked for, to start sending things you haven't asked for, our contention is they're no longer acting as an
All right,
interactive
so
computer
even
service.
if I
It's a different-
accept that you're right, that sending you unrequested things that are similar to what you've viewed, whether it's a thumbnail or an email, how does that become aiding and abetting? I'm going back to Justice Thomas's question, okay? Which is, if they aren't purposely creating their algorithm in some way to feature ISIS videos, if they're, I mean, I can really see that an internet provider who was in cahoots with ISIS provided them with an algorithm that would take anybody in the world and find them for them.
So something I just thought about here.
Yes.
So, okay. Would this apply to, like, Tinder? Like, what if... Okay, so Tinder gives you an algorithm of people, and they don't background check these people. They don't even, like, make sure they're a real person. Like, you can get catfished on Tinder all the time. It said there was an error. I don't know.
What?
Are we still live? It said there was an error on my end.
I think we're still live.
Okay, here we go. It was just my recording, I think. Okay. Anyways, I guess I can't record it, but okay. But like, so like, let's say you go on a date with someone you meet on Tinder, and like they put a drug in your drink or something, and they drug, like, would Tinder be responsible for that because they pushed the algorithm towards that person onto you? You know what I mean? And I don't know. You don't
see
have
what
to.
you're saying.
Like, how far of a scope is this, is what I'm wondering.
I feel like that's
I mean, I get it's different a little bit.
yeah.
But, like, it's still, like, the ultimate argument is that the algorithm is pushing negative content towards you. And, like, on Tinder, you know, the content is the people. You know what I mean?
Yeah. I guess but I don't know if there's any, like, I don't know how you would differentiate this legally, legislatively, but because, like, Tinder, you have to match with them
Right.
to, like, be able to start a conversation, and if you, like, once you match, Tinder is, like, not involved at all. So they may, like, on your, like, when you're swiping left or right, they choose who they're going to put next with their
Yeah.
algorithm, but once you match or don't match, then they're, like, they don't pop up in your messages and recommend, like, hey, you guys should go and meet at this club or something, you know?
Oh, yeah, no, for sure. Like, but I mean, even if you meet in a public place, like, stuff can still happen, you know?
No, yeah. But I'm saying that you, once you match, then you are, like, and I don't know. 'Cause
I wonder if
everybody's
it-
responsible for their own decisions. So even if YouTube were to recommend ISIS videos, if you were to follow that, you are still responsible for that action.
Oh, yeah,
But
no,
think-
I mean, I agree with that as a concept. I guess I'm thinking more legally. But yeah. But no, I mean, I get what you're saying. Although, like, I mean, even if you're, like, as careful as possible, like, anything can still happen. But, like, I mean, I get what you're saying, though, too. I mean, it's different with the ISIS video because, like, you're actively choosing to engage in that as the content viewer. Whereas with Tinder, like, if something happens to you, you're not actively choosing to do something bad. Like, something is happening to you as a result of the algorithm. Or not just, not as a result of the algorithm, but you know what I mean.
Yeah. And I guess I still see it as, like, with YouTube's algorithm, it's recommending a video. whereas Tinder is just person.
Right.
So like a video can have, like, yes, a person can be awful, a terrible human being. That doesn't matter. But like, I guess I'm thinking of the content, like having somebody pay Tinder profile recommended to you isn't, like, I guess I see that less evil as comparatively to like having an ISIS video recommended to you.
Yeah,
like,
because Tinder
content
can't
itself.
monitor every single because like someone can have a completely clean record and everything and they could still do something bad. Like even if they did background checks on everybody that used their site, you know?
Yeah.
Like they don't have a way to completely moderate that. And I wonder if it's in their terms of service. Like I wonder what their terms of service is like in that aspect where it's like you're responsible for, you know, what happens after you match or whatever. Or like what happens after you meet it. I don't even know what their terms of service are. I never read them, but
I don't think anybody read terms of service. We should.
Yeah. Yeah. If we had robot brains.
But yeah, I guess I would see that as different because recommending someone Tinder profile isn't a full 3-minute video detailing how you can help ISIS, you know?
Yeah. No, yeah.
Whereas
And
YouTube's algorithm is recommending videos on how, I guess I don't know what the videos were, but I mean, I hope they would have taken them down by now if they're getting sued.
I mean, yeah, but
algorithm.
There's always new stuff popping. I mean, look at Kia Boys on TikTok. Oh my god.
I don't know what that is, but
they're the ones who started the TikTok trends where they taught everyone how to steal like the Kias, and then other people started teaching people how to steal Hyundais too.
Oh.
That's why my car got stolen twice. I'm pretty sure. I blame the Kia Boys.
They have an account like that?
I don't know if they still have an account or not. I never actually like went on their account or saw their content, but
yeah, I guess it would be hard to like legally, because then they would have to specifically say like YouTube's algorithm. But then if a new company starts an algorithm, then they wouldn't be held responsible to that law if it was. And like, I don't think they ever have made laws specific to companies. Like it has to be overreach, like for that specific business. So I guess what is YouTube considered? Like I think they said it, but like an interactive computer service. I don't even know what that is, but that's what they keep calling it.
Oh, I think that's just like a website or an app.
I'm gonna just look.
That's what I would guess, but yeah, you can look it up just to be sure.
Interactive. Why do you want to know my location? Google. So the term interactive computer service means any information service system or access software provider that provides or enables computer access by multiple users to a computer server, including specifically a service or system that provides access to the internet and systems operated or services offered by libraries or educational institutions.
Okay. It just sounds like a web page, like an interactive web page.
Yeah, basically like, I feel like anything, even H&M.
Yeah.
Like clothing, like their online websites.
Right. That would be, yeah, I would think that would be included. Like any website, really.
But, okay. So 230 applies to interactive computing services then, I'm guessing.
Yeah.
Okay.
Okay.
And do recruiting of people by showing them other videos that will lead them to ISIS, that's an intentional act, and I could see 230 not going that far. I guess the question is, how do you get yourself from a neutral algorithm to an aiding and abetting?
Right.
An intent, knowledge. There has to be some intent to aid and abet. You have to have knowledge that you're doing this.
Yes.
So how do you get there?
So if the algorithm recommends an ISIS video or it automatically plays it, that, as we'll see tomorrow, that by in itself isn't going to satisfy aiding and abetting. Aiding and abetting requires knowledge that it's happening. So the elements of the aiding and abetting claim, which we'll be talking about tomorrow, address the question you're asking. If this was teed up, if they didn't know it was happening, and the other elements of an aiding and abetting claim were present, they would not be liable for aiding and abetting.
Thank you, counsel. Just one short question. Your friend on the other side presented an analogy that she thought would be helpful, which a bookseller that has a table with sports books on it, and somebody comes in and says, I'm looking for the book about Roger Maris, and the bookseller says, well, it's over there on the table with the other sports books. Isn't that analogous to what's happening here? You type in ISIS.
I'm not sure where that gets us. I mean, it wouldn't be any different than.
Well, we'll figure out where we get it gets us in a minute. But I just want to know if you think that's a good analogy.
I'm a little concerned to know where it's taking me. It's an analogy of sorts.
That's what we call questions.
But at some point I'm gonna go yes, but you still have to fit it within the four walls of the statute. Perhaps you could tell me what lies ahead. I think I could. I mean, sure, it's an analogy of sorts. But what
lies
what
ahead is I give up.
to? Yes, yeah. But
no, what lies ahead is the idea that you can look at that and say it's not pitching something in particular to the person who's made the request. It is recognizing that it's a request about a particular subject matter, and it's there on the table, and they might want to look at that, or they may not want to look at it. But it's really just a 21st century version of what has taken place for a long time in many contexts, which when you ask a question, people are putting together a group of things, not necessarily precisely answering your question. I mean, if somebody says...
Yes, no, all right, I think I know where we're going here. Insofar as I go to YouTube and I say, show me a cat, it's a more complicated than this, but tell me what cat videos you have, and they're responding to that.
Sure, that's an easy case. They give you a bunch of cat videos. You don't have any complaint about something like that. In this case, if they put in something, say, show me ISIS videos, they would get a bunch of ISIS videos, and you don't have any objection to that, given the way the search was phrased.
I have to answer that with precision. If I say, play for me an ISIS video, and they just directly play the video, then what they've done falls within the language of the statute. It's requested, it's purely third-party content, and I would trying to be holding them liable for displaying that content. But what actually has happened, and this is maybe analogous to what goes on to some extent at Twitter, where they might actually literally just show you the thing. But what's happening at YouTube is they're not doing that. I type in ISIS video, and they're going to be a catalog of thumbnails which they created. It's as if I went into the bookstore and said, I'm interested in sports books, and they said, we've got this catalog which we wrote of sports books we have here, and handed that to me. They created that content. And if you publish content you've created, you're not within the four walls of the statute. So
but
a lot depends on exactly things.
Under your theory, they would not be liable for the content of the books. They'd be liable for the catalog?
But providing the catalog.
Okay, thank you. Justice Thomas, anything further?
What if the YouTube, instead of automatically providing this list, which is hard, it's hard for me because I don't see this I see these as suggestions and not really recommendations. because they don't really comment on them. But what if you had to click on something like, for more like this, click here? Would that also be, as far as you're concerned, aiding and abetting? Or outside this statute?
It's so you've played one video and they
More like this.
no, suggestions are depending how it happens. Let's say they say send me more, show me more thumbnails. It's outside the statute. And if I might come back to an earlier part of what's embedded in your question, we aren't asking the court to adopt a rule that's about recommendations versus suggestions. What we're arguing is that you take the normal standards in each of the elements and you apply it to what's going on. It doesn't matter if they're encouraging it. If in terms of aiding and abetting, if someone comes to me and says, "What's al-Baghdadi's phone number? I'd like to call him," and I give him the phone number, I'm aiding and abetting, even if I don't say, "And I hope you'll join ISIS." Whether we label it a recommendation or not, on our view, is not the issue here. We tried to say that in our brief. Was that responsive? I'm not.
Well, it's responsive, but I don't understand it. You called. If you call information and ask for Abadadi's number, and they give it to you, I don't see how that's aiding and abetting. And I don't understand how a neutral suggestion about something that you've expressed an interest in is aiding and abetting. I don't understand it. And I'm trying to get you to explain to us how something that is standard on YouTube for virtually anything that you have an interest in suddenly amounts to aiding and abetting because you're in the ISIS category.
Well, again, I'll be answering that probably again tomorrow. But what you described without more probably wouldn't. But as we'll learn tomorrow, the circumstances are far different than that. These YouTube and these other companies were repeatedly told by government officials, by the media, dozens of times that this was going on, and they didn't do anything. They did almost nothing about it. That's very different than providing one phone number through information.
Well,
but it goes to the scope of JASTA, not to 230.
So we've gone from recommendation to inaction being the source of the problem. And this is what I understand you're putting it in context, but it's hard for me to also to understand where this obligation to take specific actions can lead to an aiding and abetting claim.
Well, the interconnection in this case is that we are focusing on the recommendation function, that they're affirmatively recommending or suggesting ISIS content, and it's not mere inaction. Mere inaction might work under aiding and abetting, but we'll get there tomorrow. But the claim that we're focusing on today is that in fact they're affirmatively recommending things. You turn on your computer, and the computers at YouTube send you stuff you didn't ask them for. They just send you stuff. It's no different than if they were sending you emails. That's affirmative conduct.
Justice Alito? I'm afraid I'm completely confused by whatever argument you're making at the present time. So if someone goes on YouTube and puts in ISIS videos and they show thumbnails of ISIS videos, and don't tell me anything about the substantive underlying tort claim. If the person if YouTube is sued for doing that, is it acting as a publisher simply by displaying these thumbnails of ISIS videos after a search for ISIS videos?
It is acting as a publisher, but of something that they helped to create, because the thumbnail is a joint creation that involves materials from third party and a URL from them and some other things.
So if YouTube uses thumbnails at all, it is acting as a publisher with respect to every thumbnail that it displays.
Yes, they're publishing the thumbnails, and the question is, are the thumbnails third-party content, or are they
Hold
content
on.
they've created?
Yeah,
And
one
the problem is,
Okay.
YouTube doesn't make the thumbnails. No, we do.
Right.
Like
Well,
the read
YouTube
of
has
the video.
they make automatic thumbnails, but if you can always add your own thumbnail in too.
Oh yeah, I guess they do automatic,
But not all the thumbnails are created by YouTube.
no. And the automatic ones are just the scene from the video.
Right.
It's not like they went and created a really cool, unique cover for your. They just pick a random
Right.
scene.
It's
from
just
your
like a
video and
screenshot
use
from the
that
video.
Yeah. So they're still not making it. Thumbnail.
They're publishing their. I mean, they technically made it by
Yes,
screen
yeah.
capping it. You know, even if it's not a creative
I guess.
endeavor. You know, like they're technically creating it, but like still.
Yeah, I mean, I guess.
But I mean, not all thumbnails are made by YouTube. Like people do make their own thumbnails a lot of the time.
Yeah, most people. I'm pretty sure most of the videos that YouTube algorithm pushes are with the made thumbnail.
Yeah, I would think so. I would think most of them are. Yeah.
I mean, maybe unless you've been watching videos where it's not like a custom made thumbnail. So
Yeah.
it'll recommend non-custom made like that because it thinks you like those kind of videos or something. I don't know. But,
Yeah.
Okay.
But they do create the algorithm which reads the thumbnails, though.
Yeah.
Right.
I guess I just keep getting confused with.
Yeah, I don't know why they're talking about who makes the thumbnails specifically.
Yeah, I just feel like they keep going like around in circles,
Yeah.
but also adding in things that don't matter. Like,
Yeah, like it doesn't make a lot of sense.
because I feel like the main conversation should just be I guess, I mean, they're talking about aiding and abetting. I guess I don't.
Yeah, and I mean, they're saying because you have to be consciously aiding and abetting. Like you can't accidentally aid and abet. So like that wouldn't really apply to the algorithm because they don't know a lot about the algorithms. But that's the problem with the algorithms is that they don't know enough to be held accountable for their algorithms. And the more that they know about their algorithms, the more likely they are to be held accountable. So of course that's an incentive for them not to dig deeper into that.
Yeah.
And I mean, they would want to know some stuff, like, to make their algorithm work better, but...
Yeah, I guess I think that they should be responsible for their algorithm, but I don't think that they could be. Because at the end of the day, you still have a choice to watch whatever their algorithm pushes to you.
Yeah, like...
But they should be responsible for the algorithm in the sense of if it's pushing more negative content towards people, or
Yeah.
maybe have a system built that will like alert them if somebody, so that, I don't know. I mean, people probably wouldn't make that because that would be a violation of freedom. But
Yeah.
I mean, if one YouTube channel is watching 500 ISIS videos, it might be good for the government to check in on them, you know, or like
Right.
the police or something. So
You would think so.
the algorithm can monitor for that,
Yeah.
because then they don't even have to take down the videos. They can just be like, hey, this person keeps watching some sketchy videos,
Yeah.
you know, government, and it's in your hands, you know.
And I mean, I do like the idea, but then there's the other side of it of, like, how far do you go with that? You know, like, what if somebody's watching, like, a bunch of, like, Matt Walsh videos? You know what I mean? Like, they're not, I mean, the government doesn't necessarily need to check in on them, but they might, if it's a lot, you know? But, like, that would be my opinion, though. So, like, that would be...
Socialism is scary.
What?
You watch one socialism video, you're in jail.
Yeah, exactly.
So, like, I get, because then it's just another monitoring, like, citizens type situation, but
Right. But then, like, if it's, like, actual, like, criminal behavior, though, that they're, like, if it's, you know, aiding and abetting, like, dangerous criminal behavior, then like ISIS videos would be, then obviously, yeah, that would be a point where the government should intervene.
Yeah. And I guess like I'm not gonna even say like I don't feel they can be like, I mean, I'm not a judge or anything, law student or any or even lawyer or whatever, but like I just don't see that they can be held responsible for aiding and abetting.
Right,
So I guess
because
that's
they're
the
not
whole
consciously
argument,
doing
and
it.
this case I feel like is what it shouldn't go through.
Yeah, well, yeah.
I mean, they should be held responsible for the algorithm, but if that's not what this lawyer's like defending or whatever, then I guess
Yeah, I don't think the aiding and abetting case is going to work here.
yeah.
Which is
I don't know.
ultimately, even it sucks for the family, but it's good for the internet,
Well,
though.
yeah, and I mean it's still something to have a discussion about,
Yeah, and
especially the algorithm.
oh yeah, we definitely need to have more discussion about like what we do need to do to hold people accountable for certain things, like companies accountable for certain things on their websites without going overboard.
Yes, yeah. Here, I'm gonna just use the restroom. I'll be right back.
Okay, I'll put the be right back screen on.
Okay.
All right, we are back. I'll move this closer to me so I can see. Okay. Are you ready?
Yes.
Yes, they are content.
I mean, if that's your argument, then you're really arguing that that the statute does not provide protection against a suit that is in substance based on the third-party provided content.
No, we're basing the. I'm sorry, I don't mean to be so.
Okay.
The particular business model they have involves using these thumbnails, which are materials they've in part created to operate.
So they shouldn't use thumbnails at all. If they want protection of the statute, they shouldn't use thumbnails.
That's the problem they have with the way the statute is written. So if I may give us.
Is there any other way they could organize themselves without using thumbnails? I suppose if you type in, I want ISIS videos, they could just put ISIS video 1, ISIS video 2, and so forth.
That's the technical problem they have.
Would that be acting as a publisher if they did that?
Yes, but they'd be publishing third-party content because the video itself is the content. But if I might respond to that.
I have one final question. It's a technical question. It's probably better addressed to Ms. Blatt. Is it your contention that everybody who uses YouTube and searches for a video involving a particular subject will be automatically presented with thumbnails that are related to that regardless of that user's YouTube setting, preferences YouTube allows you to?
I don't know. The practices are too varied. I don't know. But if
you don't know if somebody uses YouTube, they is there a function that allows them not to be presented with similar videos?
I don't know. I mean, I've gone on video on YouTube, never seen that, but I wouldn't.
Okay.
The functions that are widely varied. But if I might make a broader point about the way you framed it.
Well, I think you answered my question. Thank you.
Justice Sotomayor?
I do. This has gone further than I thought, or your position has gone further than I thought. No provider or user of an interactive computer service shall be treated as the publisher or speaker of any information provided by another information content provider. And I thought that you started by telling me if I put in ISIS and they just give me a download of information, the internet provider is not liable, correct? Under C1, I just read to you C1, correct?
It depends what the information is they give you.
If they give me
you
everything
information they've created, they're not protected.
So you are.
Wait, why does it depend on the information that they're giving you? Wouldn't it all just be content from another content provider? That's the part of this I don't get.
Well, I think he said if they created it. But
yeah, I guess if they technically created the thumbnail. But
well, I think I guess I don't know.
I think that's what it's applying.
I think that's the whole argument, though.
Right.
That they're responsible for the thumbnails, which I guess I disagree with that. I know that I
don't agree with that.
Create custom thumbnails if you don't make your own, but if anything, maybe they could just have it be a blank black square with an X in it until you manually go in and put your own thumbnail, so they would force you to create your thumbnail.
Yeah, like even if it is just from a point in your video. Even if it is just like a screenshot from your video, like they would still.
You should still have
if they just changed the function so that you would have to physically click something to publish that.
Then it would be your.
Then it would be third-party content. So that's all they would really need to change then.
Yeah, that's all they.
Which they could easily do.
Yeah.
Going to the extreme. Assume I don't think you're right. I think you're wrong. That if I put in a search and they give me materials that they believe answers my search, no matter how they organize it, that they're okay. Do you survive? Does your complaint survive if I believe 230 goes that far?
So it depends on what materials they present you with. If all they presented you with, Twitter would maybe be a cleaner example, is materials created by third parties. What they've published is third-party materials, and they're good. If they present you with things that they wrote at the other extreme, then they're not protected because what they presented is not third-party content.
So why do you think the thumbnails are? I type it in, they give me a thumbnail of everything they think answers my inquiry. The suggestion box.
Yes.
Why are they liable?
Because a thumbnail is not exclusively third-party material. It's a joint operation, and it combines. If you look at the thumbnail, it'll have a picture, which comes from the third party. It has an embedded URL, which comes from the defendant, and it might have some information below the...
The URL tells you where to find it, correct?
Sorry?
The URL tells you where to find it. It's a computer language that tells you this is where this is located.
Yes, but it is information within the meaning of the statute. This is no different than in an email which writes it out for you.
If I don't accept your line, assume that you've lost on that width of that line. I gave you an example earlier of an internet provider working directly with ISIS and doing an algorithm that teaching them how to do an algorithm that will look for everybody who is just ISIS related. There's more a collusion in the creation than a neutral algorithm. How do I draw the line between not accepting your point about the thumbnails and going to the other extreme of active collusion? Because there has to be a line somewhere in between. It can't be merely because you're a computer person that you can create an algorithm that discriminates against people. You have no problem with that, right?
The writing of the algorithm would probably constitute aiding and abetting.
Exactly. If you write one that discriminated against people for a user, you're probably going to be liable.
Yeah.
I'm not sure, as we describe it, it would fall outside the four walls of the defense. If you write an algorithm that in response the way you implement it is going to put you outside the defense.
If you write an algorithm for someone that in its structure ensures the discrimination between people, a dating app, for example, someone comes to you and says, I'm going to create an algorithm that inherently discriminates against people. It won't match black people to white people, Asian people to Hispanics. It's going to discriminate. You would say that internet provider is discriminating, correct?
I would. What they did, the way the distinction played out would be important, though. They would, if they're, they would have to fall outside of one of the elements of the claim. It's hard to do this in the abstract.
Justice Kagan?
Mr. Schnapper, can I give you three kinds of practices and you tell me which gets 230 protection and which doesn't? So one is the YouTube practices that you're complaining of, and we know you think that does not get 230 protection. A second would be Facebook or Twitter or any entity that essentially prioritizes items. So you're on Facebook and certain items are prioritized on your news feed, or certain tweets are prioritized on your Twitter feed, all right? And that there's some algorithm that's doing that and that's amplifying certain messages rather than other messages on your feed. That's the second. And then the third is just a regular search engine. You put in a search and something comes back, and in some ways, that's one giant recommendation system. Here's the first item you should look at. Here's the second item you should look at. So are all three of those not protected? Or what happens to my second and third? Are they protected or not protected? And if they are protected, what's the difference between them and your practices?
Certainly. So let me start with the search engine. There's a lot of discussion in search engines, but there's not a specific provision in the statute that says search engines are protected. The question is, do they fit within the language of the statute? So if I ask a search engine for stories about John Doe, and it gives me a list, and if I click on one of them, it turns out to be defamatory, they're not liable because they...
Well, they just gave it to you. It's the first thing. They've just prioritized it. They think it's really a great one to click on.
The mere there are multiple questions here. First, are they liable just because what you clicked on turned out to be defamatory? The answer we think is no. Secondly, what if the snippet that they took from the John Doe document said John Doe's a shoplifter? And the answer is they're not liable because they didn't write that. It's publishing third-party content. The third question is, could they be liable for the way they prioritize things? And the answer is, I think so. It's going to depend what happened. And the example,
So even all the way to the straight search engine, that they could be liable for their prioritization system.
Yes, there was let me...
Okay.
If I might continue...
I appreciate the... Go ahead. I'm sorry.
Those are the facts which led the European Union to fine Google 2.3 billion euros because they used prioritization to wipe out competition.
Okay, so here's...
Things that we're selling.
Yeah, so I don't think that a court did it over there. And I think that that's my concern, is I can imagine a world where you're right that none of this stuff gets protection. And, every other industry has to internalize the costs of its conduct. Why is it that the tech industry gets a pass? A little bit unclear. On the other hand, we're a court. We really don't know about these things. These are not like the 9 greatest experts on the internet. And I don't have to accept all Ms. Blatt's "the sky is falling" stuff to accept something about, boy, there is a lot of uncertainty about going the way you would have us go, in part just because of the difficulty of drawing lines in this area, and just because of the fact that once we go with you, all of a sudden we're finding that Google isn't protected. And maybe Congress should want that system. But isn't that something for Congress to do, not the court?
Well, I think the line drawing problems are real. No one minimizes that. I think that the task for this court is to apply the statute the way it was written. And if I might return to a point that Justice Alito made, much of what goes on now didn't exist in 1996. The statute was written to address one or two very specific problems about defamation cases. And it drew lines around certain kinds of things and protected those. It did not and could not have been written in such a way to protect everything else that might come along that was highly desirable. Congress didn't adopt a regulatory scheme. They protected a few things. It will inevitably happen, and has happened, that companies have devised practices which are maybe highly laudable, but they don't fit within the 4 walls of the statute. That will continue to happen no matter what you do. And the answer is when someone devises some new method, some new practice that may be highly desirable but doesn't fit within the 4 walls of the statute, the industry has to go back to Congress and say, we need you to broaden the statute because you wrote this to protect chat rooms in 1996, and we want to do something that doesn't fit within the statutes. And using thumbnails would be a perfect example of that.
Thank you.
Justice Gorsuch?
Mr. Schnapper, I just want to make sure I understand, as you say, the statutory language and how this case fits with it. And if we could start with Section 230F4, which defines the term access software provider. It includes, among other things, picking, choosing, analyzing, or digesting content. And we might, in another world, in our First Amendment jurisprudence, think of picking and choosing, analyzing, or digesting content as content providing, but the statute seems to suggest That's not what it is. It's something different in this context, in this statutory context, and it's protected. Do you agree with that?
No, and if I might explain why.
Briefly.
I'll do my best. The language that you refer to in section F4 doesn't apply here.
No, we'll get to that in a minute. But let's just take that as given, okay? That I think that what, say, Google does in picking, choosing, analyzing, or even digesting content just makes it an access software provider. Let's take that as given. And so that would normally be protected activity. But F3 carves out a scenario where you become a content provider. And that's something different, in my mind, to picking, choosing, analyzing, or digesting content. Okay, let's just take those two premises as given.
Okay.
All right? You got to do something beyond picking, choosing, or analyzing, or digesting content, which is what search engines typically do, even as I understand it. You got to do something beyond that. As I take your argument, you think that the Ninth Circuit's neutral tools rule is wrong, because in a post-algorithm world, artificial intelligence can generate some forms of content, even according to neutral rules. I mean, artificial intelligence generates poetry, it generates polemics today. That would be content that goes beyond picking, choosing, analyzing, or digesting content, and that is not protected. Let's assume that's right, okay? Then I guess the question becomes, what do we do about YouTube's recommendations? And as I see it, we have a few options. We could say that YouTube does generate its own content when it makes a recommendation says up next. We could say, no, that's more like picking and choosing. Or we could say the Ninth Circuit's neutral tools test was mistaken.
Wait, I'm gonna look up really quick what the neutral tools test is.
Okay.
Because I'm confused. Neutral tools. Oh, okay. I think it's just a way to test if, like, the algorithms are neutral. So, like, for example, like, if it's a job application AI that's reading through job applications, it's not just picking people with, like, white names or something. Like, that wouldn't be a neutral tool. But, like, if it was, like, if it wasn't showing any kind of bias, basically.
So, like, that one judge's example of a dating, like, if it wasn't going to match white and black people or Asian Hispanics, if that would not be a neutral tool.
Yeah.
Because in some circumstances, even neutral tools like algorithms can generate through artificial intelligence forms of content, and that the Ninth Circuit wasn't sensitive to that possibility and remanded the case for it to consider that question. What's wrong with that?
Well, it's not our theory, but it's if the alternative is what Ms. Blatt will be telling you, I'll take it.
I'm not asking you, hey,
no, there's nothing wrong with it.
I'm asking you whether that is a correct analysis of the statutory terms you keep referring us to, or whether it is not.
Yes. As we've set out, that's close to something we set out in our brief, which is that the algorithm could create things on its own. It could create a catalog of ISIS videos, which would be analogous to a compilation under Section 101 of the Copyright Act. A compilation is a distinct entity. It's copyrightable, even if the elements of it were not. So, yes, absolutely, the software could create something like that. It would not be third-party content, and therefore it would fall outside the scope of the statute.
Thank you.
Justice Kavanaugh?
Just to pick up on Justice Gorsuch's questions, the idea of recommendations is not in the statute, and the statute does refer to organization, and the definition, as he was saying, of interactive computer service means one that filters, screens, picks, chooses, organizes content. And your position, I think, would mean that the very thing that makes the website an interactive computer service also mean that it loses the protection of 230. And just as a textual and structural matter, we don't usually read a statute to, in essence, defeat itself. So what's your response to that?
My response is that the text doesn't apply here. Let me explain why. The element in the list in F4 it refers to only one of the three kinds of interactive computer services in F2. In F2, and this is it is on page 267 of the petition appendix. F2 says an interactive computer service means, and it gives you three candidates. You've got to fit into one of them: an information service, a system, or an access software provider. Now, YouTube is one of the first two. It's not a software provider. The definition in F4 only delineates who is an access software provider. It doesn't apply to who's an information system or service. And that was Congress's choice. Congress didn't say you're a service, an information service or a system if you do those things. It said those things only bring you within the four walls of interactive computer service if you're a software provider. And that made sense in the context of what was happening in 1996. In 1996, if you wanted to go online, you would typically sign up with CompuServe or Prodigy, and they would literally give you diskettes. They would be selling you software. And this provision in F4 is about that activity. That's not what's happening here.
Just to go back to 1996 and maybe pick up on Justice Kagan's questions earlier, it seems that you continually want to focus on the precise issue that was going on in 1996, but then Congress drafted a broad text, and that text has been unanimously read by courts of appeals over the years to provide protection in this sort of situation, and that you now want to challenge that consensus. But the amici on the other side say, well, to do that, to pull back now from the interpretation that's been in place would create a lot of economic dislocation, would really crash the digital economy with all sorts of effects on workers and consumers, retirement plans, and what have you. And those are serious concerns, and concerns that Congress, if it were to take a look at this and try to fashion something along the lines of what you're saying, could account for. We are not equipped to account for that. So are the predictions of problems overstated? If so, how? And are we really the right body to draw back from what had been the text and consistent understanding in courts of appeals?
Well, our position is that the text doesn't say this. With regard to the issue of what we've come to call recommendations, this isn't a long-standing, well-established body of precedent. It's really three decisions. The decision in this case, the Dyaroff decision, and Force. And of the 8 justices...
What about the implications then? Go to that. The implications for the economy, that you have a lot of amicus briefs that we have to take seriously that say this is going to cause a lot of economic dislocation in the country.
I'd say a couple of things in response to that. The first one is, on a close reading of the amicus briefs, it's clear that they're urging the court to hold that a wide variety of different kinds of things are protected. They're inviting the court to adopt a rule that recommendations are protected and that whatever they're doing would qualify as a recommendation.
I think they're saying a recommendation is a recommendation, something express. And your whole thing is the algorithms are an implied recommendation, and they're saying, well, they're not an express recommendation. But in any event, why don't we
Yes.
focus on the
Yes.
question? Do you challenge the basic
I
point?
think, yes,
And if so,
we do on a couple of grounds. One of them is that I'm not sure all these briefs are distinguishing, as we have today, between liability because of the content of third-party materials and the recommendation function itself. A distinction between more and less specific suggestions.
what would the difference be in liability? In damages?
I'm sorry, between which two things?
The third-party content and the recommendation?
Well, most of the time, the recommendations...
Like, how would the money at the end of the day differ if you are successful?
It might not be, but most recommendations just aren't actionable. I mean, there is no cause of action for telling someone to look at a book that has something defamatory in it. JASTA, the statute we're talking about tomorrow, is unusual in that recommendations could run you afoul of the statute. But there are very few claims that are like that. So it's a very different kind of situation. It's the implications of this are limited because the kinds of circumstances in which a recommendation would be actionable.
Yeah, so he's basically saying the recommendation is more coercive.
Then what?
Then, so in the example, when you go and, someone tells you to go to, a certain book section to find a book, and then there's other similar books. That wouldn't be a good comparison because with the website, there's a call to action, which is, when you, kind of highlight, a path for the website user to take. So, when there's a big button that, stands out that says login or something like that would be a call to action in, UI. In the UI.
Oh, so what's he...
So he's saying, the recommendations are, coercive, basically. Because they, in the sense that, they kind of guide you towards where to go next on the website.
Hmm.
So I think that's what he's trying to say here.
Okay. I feel like it's just hard to follow him a little bit.
It is hard to follow him, I agree.
Because, it just... I feel like he just needs to, stick with some... But, I mean, I know, they're giving him different... What are those called? Scenarios, and then he has to either fit them into his claim if it works, or try to denounce that it doesn't fit his example. But
yeah, okay.
But they're not even mentioning thumbnails anymore, and that was the whole thing in the beginning.
Yeah. They're just getting lost in the sauce here.
Yeah.
Well, let's see where this goes next, then.
Are limited.
Thank you.
Justice Barrett?
I'd like to take you back, Mr. Schnapper, to Justice Sotomayor's questions about the complaint. It seems to me that the complaint in this case is materially indistinguishable from the complaint in tomorrow's case. Do you agree? Same
in which case?
In tomorrow's case, in the Tomno case, the Twitter case, and this one.
Pretty much.
So they're both relying on the same aiding and abetting theory. So if you lose tomorrow, do we even have to reach the Section 230 question here?
Wait, so Twitter's getting sued for the same thing?
I guess so. I don't know what the...
I saw a Twitter case on the page when I went to find this, but I didn't know what it was about.
We can watch that one sometime.
Yeah.
But yeah, I don't know about that one, I guess. Or I didn't know about this one either, but
yeah,
that's why we're listening.
Yes.
Would you concede that you would lose on that ground here?
No. There was a motion to dismiss in tomorrow's case on JASTA grounds. It didn't get decided. So if we lose tomorrow, the defense will be free in this case to to move to dismiss, but we'd be entitled to try to amend the complaint in this case to satisfy whatever standard you establish tomorrow.
Okay, let me ask you this. I'm switching gears now. So Section 230 protects not only providers, but also users. So I'm thinking about these recommendations. Let's say I retweet an ISIS video. On your theory, am I aiding and abetting, and does the statute protect me, or does my putting the thumbs up on it create new content?
We don't read the word user in that broadly. There's not been a lot of litigation about this. We think the word user is there to deal with a situation in which one entity accesses a server, YouTube, for example, and then someone else uses that entity. Like when I go to FedEx office. FedEx office is the user that is accessing my email. And the statute protects them when I look at the FedEx computer and find the defamation.
Let's say that I disagree with you. Let's say I'm an entity that's using the service, so I count as a user. You know, my computer is accessing the servers when I retweet the image. On your theory, could I be liable under JASTA for aiding and abetting? Do I lose 230 protection if I created new content?
Whether it's enough for JASTA is a separate
Okay,
The question is it outside?
Is it outside of 230?
And our view is the statute doesn't mean anyone who's a user who conveys third-party libel is protected. If you, let's say that you read a book and it says John Doe is a shoplifter, and you send an email that says John Doe's a shoplifter, you're using the internet. You're using the email system. But nobody thinks that Section 230 is a blanket exemption for defamation on the website as long as you're quoting somebody else. Retweeting is a very automatic way of doing it. But if you start down that road, you'd end up having to hold that any time I send a defamatory email, I'm protected as long as I'm quoting somebody else. I don't think anybody...
I guess I don't understand. I mean, let's see. I guess I don't understand logically why your argument wouldn't mean that I was creating new content if I retweeted or if I liked it or if I said, check this out. Why wouldn't that?
You would be, but I'm advancing an argument that gets to the same place, which is you're not a user within the meaning of the statute just because you go on email or YouTube or
Let's
Twitter.
say I disagree with you. Let's say that I think you're a user of Twitter. If you go on Twitter and you're using Twitter and you retweet or you like or you say, check this out. On your theory, I'm not protected by Section 230.
Yeah, that's content you've created.
That's content I've created. Okay. And on the content creation point, let's imagine it seems like you're putting a whole lot of weight on the fact that these are thumbnails, and so it's something that YouTube separately creates.
Yes.
What if they just screenshot? They just screenshot the ISIS thing. They don't do the thumbnail.
Yeah.
Then
that's pure third-party content.
That's pure so this is...
Okay. So, I guess when it screenshots the thumbnail, then it's not their creation.
They don't ever create thumbnails then.
Right. Like, I don't think they make custom thumbnails. Unless they have deals with, like, the people they, like, pay a lot of money to and stuff. But I don't think...
Yeah,
no, I think they
I
hire
don't
people to
think-
make thumbnails for them.
Like the content creator?
Yeah.
Yeah, probably. They don't
Like,
make
I don't
their
think YouTube makes those.
No, I don't. And if, like, in your scenario, if YouTube was working with them, then they would have been working with ISIS, and then yes, they could have been aiding and abetting, but
Right.
I don't think...
But I don't think they were working with ISIS, though.
Yeah. Like, yeah, there's some... So, like, that's why I get still... Well, because then earlier they mentioned the thumbnail because it has the URL, the joint thing. But to me, I don't know. That
Yeah, I don't know. I think... I don't think a URL should count as posting content.
URL.
Like, I don't think the URL should separately count as content in itself. Because
But
that's
that was-
just the address.
Like, because the thumbnail had the URL in it. That was his claim that it was a joint thing.
Yeah, I don't know. I don't agree that a URL counts as content.
No, I don't either. Like,
I think that's stupid. In my
like,
opinion.
unless the URL led to YouTube, like a YouTube article that was published by YouTube. But if that URL leads them to the third party content,
Then
like
I would think the URL, even if it was content, like if it's a video that was posted by a third party, then the URL would belong to the third party because it's their video.
Exactly.
Yeah. So yeah, this argument doesn't really make much sense to me.
No, I don't think it makes. And that's okay. It is what it is sometimes.
Yeah, but I think a lot. It sounds like a lot of the judges aren't in, like, it sounds like they're disagreeing with him, like in the way that they're questioning.
I think there were maybe one or two times where, like, I didn't fully understand what they were saying, but like the defense or whoever, the lawyer they're talking to right now,
Yeah.
seemed to like that statement. So like I do think they're trying to like they're trying to find points that go with him and points that go against him, and just,
Yeah, they're trying to figure it out.
And see what the answer here, but
Yeah.
we haven't even heard the other lawyer yet.
Right. Oh, I wonder how long that one is.
Well, I think,
or are they together on this? I don't know how it's set up on this site.
let me quickly just scroll through. Yeah, it looks like Mr. Stewart will be in this one.
Oh, okay.
Who I'm assuming is the other lawyer.
Yeah. Okay.
I think soon, actually.
Okay.
But yeah,
Yeah, I think maybe once we get to that one, we can split it and then do the rest like tomorrow.
Yeah, that works.
Okay. Cool.
I don't know what. We'll just have to listen here. I don't know if they like the known.
Yeah.
I don't know. We'll just try to listen for when the next lawyer hops in.
Yeah. And I mean, if it's not perfect, that's okay too. But yeah. Okay.
Just about how YouTube set it up.
That's correct in this context. And it gets back to the conversation we were having earlier about that this is a new technology that didn't exist in 1996, and rather than ask Congress to write the statute to cover it, they just went ahead and did it.
Okay, and last question. Turning to the statutory text. So it seems to me some of the briefs in this case are focusing on what it means to treat someone as a publisher, treat an entity as a publisher. You're not really focusing on that and the traditional editorial functions argument. I mean, you're really focusing on the content provider argument, correct?
No. Well, we've advanced views as to each element of the claim.
But today you've really been honing in on this. Are you actually creating content or just presenting third-party content?
Well, I've been answering. That's where the questions have taken us. But our view would be that you're not being treated as a publisher of the video just because you published the thumbnail.
Okay, thank you.
You're not being harmed by the thumbnail.
Thank you.
Justice Jackson?
So I guess I'm thoroughly confused, but let me try to understand what your argument is. And I think that the confusion that I'm feeling is arising from the possibility that we're talking about two different concepts and conflating them in a way. I thought that Section 230 and the questions that we were asking in this case today was about whether there was immunity and whether Google could claim the defense of immunity. And that's actually different than the question of whether whatever it does gives rise to liability. That is there liability for aiding and abetting? That's tomorrow's question. And to the extent that you keep coming back to this notion of creating content or whatnot, I feel like we're conflating the two in a way that I'd like to just see if I can clear up from my perspective. Your brief says that the immunity question, Section 230C1's text, is most naturally read to prohibit courts from holding a website liable for failing to block or remove third-party content. And I read the arguments in your brief, and I read what you said about Stratton Oakmont and the sort of background. And so I thought your argument was that you can only claim immunity, Google, if the claim that's being made against you is about your failing to block or remove third-party content. To the extent we are making a claim about recommendations or doing anything else, any of the hypotheticals that people have brought up, that's outside of the scope of the statute, because really the statute is narrowly tailored in a way to protect internet platforms from claims about failing to block or remove, right? I mean, that's what I thought was happening. All right, so if that's true, then all the hypotheticals and the questions about are you aiding and abetting if Google, has a priority list, or if there's recommendations, maybe, but that's not in the statute, because we're just talking about immunity. We're just talking about whether or not you've made a claim for failing to block or remove, in this case today, related to Section 230. Am I doing too much of a separation here in terms of how I'm conceiving of it?
Well, let me articulate what the contention is that we are advancing, and I think it's not quite the way you describe it. The contention we're advancing is that a variety of things that we're loosely characterizing as recommendations fall outside of the statute.
Why?
Because in some of them, the defendant's not being treated as the publisher, because in some of them, third-party content's being created by the defendant, because in some of them, the defendant's not acting as an interactive computer.
I see. So I thought the answer to why was because the statute is limited, because the statute only focuses on certain kind of publisher conduct, and to the extent that they're doing anything else, recommending or whatever, that's not going to be covered by the statute. But you're sort of saying, well, let's look at what they're actually doing, and it may fit in or it may not. You're not sort of hewing very closely to the understanding of the original scope of the statute in terms of what it is trying to immunize these platforms against.
I think what we're trying to do that in a somewhat more particularized way, that is to identify, to work our way through each of the three specific elements of the statute, each tied to particular language.
But I got to tell you, I don't see three elements in this system. I mean, part of this is all the confusion, I think, that has developed over time about the meaning of the statement in the statute, right? I don't see three elements. I see literally a sentence. And the sentence, in my view, reads as though they're trying to actually direct courts to not impose publisher liability, strict publisher liability, against the backdrop of Stratton Oakmont. So there's like somehow we've gotten to a world in which we've teased out three elements and we're trying to fit it all into that, when I thought there was sort of a very simple, sort of straightforward way to read the statute that you articulate in your brief, which is this statute, C1, is really just Congress trying to not disincentivize these platforms for blocking and screening offensive conduct. And so what they said is, let's look at C1, let's have C2, let's have a system in which a platform is not going to be punished, strict liability for just having offensive conduct on their website. And if they try to screen out, we're going to say you won't be responsible for that either. That's C2. But it really doesn't speak to whether you do a recommendation or whether you have an algorithm that does priorities or any of these other things. That's how I thought that at least I was looking at the statute in light of its purposes and history and Stratton Oakmont and all of that, in which case I think you would win unless your recommendations argument really is just the same thing as saying they're hosting ISIS videos on their website.
Well, I think we do have to be drawing that distinction. But with regard to your question about the three elements, the the text does take you there. It says, if you track the briefs, I think probably of either side, we're arguing about the meaning of treat as a publisher because that's the first couple of words of the statute. Then we're arguing about did they create the content because publisher has to be of information provided by another content provider. So we have to parse out the meaning of that. And then it refers to the defendant as an interactive computer service, and we have to parse out the meaning of, well, what does that mean? So we are forced to, the language of the statute has those three components. And although the overall purpose, I think, as you described it, the language is more complex and particularized.
Thank you.
Thank you, counsel. Mr. Stewart?
Thank you, Mr. Chief Justice, and may it please the court. I'd like to begin by addressing the Roger Maris hypothetical because I think it illustrates our position and the limits on our position. Imagine in a particular state there was an unusually protective law that said no bookseller shall be held liable on any theory for the content of any book that it sells. And then the scenario that the Chief Justice described occurred. The person was asked, where's the Roger Maris book? And said, it's over on that table with the other sports books. Now, if the bookseller was sued for making that statement, our position would be there's no way textually that the immunity statute would apply. This is a statement about the book, not the contents of the book. Now, the statement, the book is over there, is so obviously innocuous that it might seem like pedantry to quibble about should the dismissal of the suit be based on immunity or for failure to state a claim. But a court, in thinking about the possibility of harder cases down the road, should distinguish carefully between liability for the content itself, liability for statements about the content. And the one other thing I would say is, if the consequence of saying it's over there was that the bookseller lost its immunity for the content of the book, that would be a big deal. But our position on 230C1 is nothing like that. Our position is that the internet service provider can be sued for its own organizational choices, but the fact that it makes organizational choices doesn't deprive it of the protection it receives for liability based on the third-party content. I welcome the court's questions.
Okay, so I think the book example is kind of interesting because, like, it's kind of saying, like, the algorithm is almost a way to organize web addresses, in a sense. And they're organizing them by relevance in content. Does that make sense?
Yeah, I think so.
So I think that's an interesting example to bring up.
Well, because then earlier they say that YouTube owns the copyright for those, like if they were to release a compilation of videos, like you know how like books, I don't know, they mentioned it somewhere, something like, it made it sound like, you know how like on YouTube there will be like a list like that's recommended.
Yeah.
It almost seemed like they were making it seem like YouTube owns that list.
Right. Okay. Interesting.
So then they're trying to say they're responsible for that, I think, is one of their, I don't know.
Okay. That makes sense. Interesting.
Yeah.
Well, I'm still confused, but what if the bookseller said it's over there on the table with the other trustworthy books?
I mean, I think at that point you would be asking, could it conceivably be an actionable tort to describe the book as trustworthy?
Well, we're putting a lot of weight on organization, but doesn't it really depend on how we're organizing it and on what the basis of the organization? For example, we could say you could organize it on the basis of what's more trustworthy than something else.
I think that might matter with respect to whether there was substantive liability under the underlying cause of action. It shouldn't matter for purposes either of the hypothetical immunity statute I described, which focuses exclusively on the contents of the books, or for 230C1. Now, Mr. Schnapper said in a colloquy earlier that he thought the allegations in his complaint are basically the same as those in the Twitter complaint. And the government is arguing in Twitter that those allegations are not sufficient to state a claim under the Anti-Terrorism Act. So our interest in 230C1 is not in allowing this particular suit to go forward. It is in preserving the distinction between protection for the underlying content and protection for the platform's own choices.
Well, I just think it's going to be difficult. How would you respond to Justice Gorsuch's hypothetical about the artificial intelligence creating content, organizational decisions?
I mean, I think the organizational decisions could still be subjected to suit, whether you think of them as recommendations or simply as the platform, the operation of the platform. It's still the platform's own choice. And if you ask, how did a particular video wind up in the queue of a particular individual? It could be some sort of artificial intelligence that was making that choice, but it would have to do with the YouTube's administration of its own platform. It wouldn't be a choice made by any third party who had posted, because third parties who post on YouTube don't direct their videos to particular recipients. And I do want to emphasize this theory, this rationale applies even in the most mundane circumstances. For instance, if you do a Google search on the name for a famous person and you misspell the name slightly, you still get lots of content about that person. Google knows that it's smarter than we are, and it knows that more about what we want than the literal terms of our search might suggest. I went to the court's website and used the docket search function and typed in Google and left off the final E, and I got a message that said no items found. In order to call up the docket for this case, you have to spell Google exactly right. Now, the choice between those two modes of operating the platform, it's extraordinarily unlikely, almost inconceivable that it could ever give rise to legal liability. But those are choices made by the platforms themselves. They are not choices made by any third party. They just don't implicate 230C1. And any conceivable lawsuit about the decision to use one mode of operation rather than another presumably would be dismissed on the merits.
I think the problem, Mr. Stewart, with minimizing what your position is that in trying to separate the content from the choices that are being made, whether it's by YouTube or anyone else, you can't present this content without making choices. So in every case in which there is content, there's also a choice about presentation and prioritization. And the whole point of suits like this is that those choices about presentation and prioritization amplify certain messages and thus create more harm. Now, I appreciate what you're saying is like, well, that doesn't mean that you're going to have liability in every case. But still, I mean, you are creating a world of lawsuits. Really, anytime you have content, you also have these presentational and prioritization choices that can be subject to suit.
Let me say a couple of things about that. The first thing I'd say is you could make substantially the same argument about employment decisions. That is, in order for YouTube to operate, it has to hire employees. But Ms. Blatt acknowledges in the brief that employment decisions wouldn't be shielded by 230C1 if there was an allegation of unlawful discrimination, for instance. So the fact that the platform has to make some sorts of organizational choices doesn't mean it's immune from suit in the rare instance where it might make a choice that violates some other provision of law. The second thing is that the concern we have in mind are things like, imagine a hypothetical job matching service like Indeed, where job applicants can post their qualifications and potential employers can post their own listings and the website will match them up. And suppose it came to light that the job search mechanism was routing the high-paying, more professional jobs disproportionately to the white applicants and the lower-paying jobs to the black applicants, even when the qualifications were the same. At a general level, you could describe that as choices about which content would go to which users. But when we saw that kind of stark impropriety in the criteria that the platform was using, I think we'd say there has to be, assuming it violates applicable law, 230C1 really shouldn't be protecting that. That's not, the complaint we have here is not to the content itself or the presence of the third-party job postings on the platform. The complaint is about the use of illicit criteria to decide which users will get which content. And our point is, in the more innocuous cases or in the borderline cases where the criteria seem a little bit shaky but it's not clear whether they violate any applicable law, that choice ought to be made based on the law that the plaintiff invokes as the cause of action. And the court ought to be determining, does the use of those criteria violate that law?
I was just going to say, the problem with your analogies is that they involve, I don't know how many employment decisions are made in the country every day. But I know that, whatever it is, hundreds of millions, billions of responses to inquiries on the internet are made every day. And as Justice Kagan suggested, under your view, every one of those would be a possibility of a lawsuit if they thought there was something that the algorithm referred that was defamatory, that, whatever it is, exposed them to harmful information. And so that maybe the analogy doesn't fit the particular context.
I mean,
Wait, okay. Is this still the prosecution?
It's a new our lawyer,
Okay.
but it sounds like he is also arguing. I don't know. I'm a little lost.
Yeah. Well, do you want to put it on pause for now?
Yeah, we can. Are you gonna just write down the time somewhere so you remember?
Yeah, I'll find something to write it down on here.
Okay.
I'll just write it on this for now.
Well, I was trying to scroll quick to see if there's a third lawyer who talked. Because it sounds like they're both. It sounds like this lawyer is also trying to say that YouTube should be held responsible. Okay, there's a Mrs. Blatt, or Miss MS Blatt.
Okay.
Later on. So maybe she argued against these two?
Maybe. Yeah, I don't know how it works, but we'll see.
Okay.
Okay.
Interesting.
Okay. Thanks for watching if you made it this far.
Yeah. We'll be back tomorrow.
Yes.
And try to do it every weekend if we can.
Yeah.
But otherwise, that's all for now.
Yeah. I'll see you next time.